Okay, well, thank you for having me here. I'm very pleased to share my thoughts with you. I thought that it would be a good idea to have something, let's say, a bit more precise, not only, as we did yesterday, philosophical framework of what is going on with AI. So I will talk about the law, the rule of law, and judgment, and I will try to show what is the main problems of this field when AI is, I would say, just coming out of the blue in a world where law people are not used to computation. So I will start first with remarks on justice as a collective trust. And I think there are four basic instruments that justice uses. First one is a cordoned off space. As you know, when you go to a trial, there is a space which is empty and people are gathered around. So that's the first remark. It's the courtroom, okay? The second instrument is the specific distribution of roles, meaning that, of course, you have various parties, they don't agree, there is a conflict, and so we have ways of distributing the floor so that everybody can actually say something. There's also a set of rules, of course, which is generally written, at least in our culture today. And then there's a form of sovereignty, since the authority of the judge derives from the sovereignty of the state, which is, of course, maintained by force. So these are the four basic instruments of the rule of law, and more specifically of justice. So I'll just give you an example of what this space looks like. You, of course, know that. This is the Cour de Justice de la République in Paris. You have this empty space, and you have various locations in the room where people are supposed to stand and come to say something. So the aim of a trial is, I would say, twofold. First of all, of course, there must be some physical distance and proximity between individuals or groups in conflict, which means they are gathered in the same room as we are today. There's a capacity for mutual speech given in turns by a recognized authority, the judge. And there is a search for a mutual agreement, which is ideally reached in a final decision, so that we avoid private vendettas and collective violence. This is, of course, the main aim is to avoid that. So the legal resolution of conflicts requires a social situatedness embodied in a ritualized speciality. So this is, I think, the most fundamental, how do you say, Zonda something? In justice, the basic characteristic of what justice is about. So now, what is digital justice? What does it make to this framework? So is it only hype, as some people suggest, especially during among lawyers? So my basic observation first is that, of course, today we all know that we are facing multiple and recurrent complaints of slowness and unfairness of justice. We mentioned that this morning, when we said that, of course, judges can be biased and so on. Why not replacing them by some AI justice? And so the basic response of digital justice is to say that technology can help improve on this issue. So, of course, we are now used to using various softwares, inside and outside courts, in order to speed up the processes, like speed cameras on roads, connected to automated fining. We all know that, of course. We also have low-intensity conflicts that are settled via internet. You know, when you buy things on Amazon or something, if what you have bought comes to your place, it's broken or something, you have ways to settle that. And we also have computation of probable expectations in trials. Before the trials begin, we know, because of various cases that are rather similar, that we can expect, you know, a certain issue. So I would say that first, the digital justice brings certainly a response to this slowness complaint, but now, is it fairer? That's the big point. Is it a fairer justice? And there are basic problems of digital justice because the use of software disrupts the deep connection that I just mentioned between first the construction of a ritualized space, the distribution capacity to speak, and the authority of texts as sources of legality. So this is disrupted in very deep ways. And why is that? Well, it's just because legality is partially transferred to software, you know. And what is software? Software is lines of code. So we are supposed, and the previous talk, you know, talked about that. We are supposed to trust these software just like any other legal instruments. But is it the same to use a software and to speak in a courtroom? Of course not. So there are specific problems. So I don't think that digital justice is just another legal instrument. It's a real change because lines of codes do not pertain to the three-dimensional space. There are dematerialized tokens that are meant to be read, but not like legal texts. You know, they are supposed to be read by machines, not by us. So, and also the lines of code are not meant to record human speech, but only a written coherence of their own, which means that we can't read the code as we used to read the Code Civil, for example. You know, we can't read them, and nobody can. The judge cannot, lawyers can't, and even IT specialists can't read the codes. So what is a law that you can't read? You know, what is that? Is it possible to trust a law that you can't read? So I will first, you know, make a few remarks on how did that happen, you know, and we'll just try to specify 3 steps in this digitalization of law, and my basic claim is that it goes from a spatial world, you know, that I described in the courtroom at the beginning, to there's some kind of despatialization process in 3 steps. So the first step was very easy. You know, we thought that the digital software and digitalization in general was just an office equipment. We would have a better access to law, either for the professional or the citizen, you know, and it's of course much easier and quicker to go online and check the laws. The other day I had to prepare a PhD defense, and I didn't know exactly, you know, how I was supposed to do, and I just went on Legifrance, which is the website of the French government, got everything there. It was easy, and I knew how to proceed. Okay, so that's a good thing. Of course, we have this great access to law, and of course they can be updated online all the time, which is also a great advantage. Yeah, you don't have to move these big law books that we used to have. So this goes very far, like smart courts in China, for example, for e-commerce, where you have, you know, some kind of automatic processes of almost everything, you know, automatic summons to a Supreme Court, but automatic research of precedents, automatic collection of evidence, etc., etc. So we are going in that direction for sure. The step number 2 was a new prescriptive role for judicial software, and that happened at the beginning of the years 2000 with a very well-known article by Lessig, a Harvard professor of law, and a very famous article called Code is Law. So it's not, now it's the code which is the main source of legality, you know. And of course, this is now true in courts. You know, we have lots of databases of jurisprudence. We have civil and penal proceedings in digital format. We have the possibility to file complaints online. We have, as I said already, dematerialization of small claims or injunction to pay. And we have also the possibility for the litigants to follow the progress of the procedures online. And since COVID time, so in the last 2 years, we have video hearings without physical presence. And we have, I mean, sometimes prisoners are interviewed in prison, for example, online, so they don't go to the judge as they used to do. And outside courts, we have also a lot of online dispute settlements. You know, private companies like eBay develop their own online settlement tools, but we have also online arbitration platforms, lots of them, you know, like Case Law Analytics, Netcase, eJust, yeah, you name them. We have also certification processes, you know, legal acts. I was once in a conference of bailiffs in Belgium, and they, you know, they were really afraid of these new software coming because they were just losing their jobs. You know, they could see that in less than 10 years' time, bailiffs as a profession would just disappear. And it's also the case for notaries who are being made redundant by approved apps. By approved, I mean approved by governments. You also have automatic drafting of notarial deeds in multilingual contracts. I met entrepreneurs in France, you know, having to have contracts with Chinese partners, and they would do that online, okay? And you have a lot of risk analysis tools before engaging in a trial, as I said. The third step in this digitalization is blockchain justice. So this is really new because it bypasses completely the spatialized courts. So this is something really important, you know, so that, in fact, legal decisions are now starting to be carried out online on secured networks using blockchain protocols. And your colleague from University of Luxembourg, Catherine Becker, has studied that a lot, and we are actually working together on a project of Kleros, which is one of these blockchain courts of justice. So we are trying to explore how that works. So there are 3 main features in these blockchain courts of justice. They are totally decentralized. You know, so there is no central governance. The decisions are immutable. So, you know, you can't modify the blockchain. So once it's written down there, you know, there is nothing you can change. And it's totally anonymous. So there are no personal identities involved. And of course, in the case of law and conflicts in society, you can see how difficult it comes when you have to judge people without knowing them at all. You know, how does this work? It's a real issue. So my question as a philosopher is, can justice do without space? Can we really get rid of space and courtrooms as we used to have for a very, very long time? So the question is the transfer of legality from a spatial and linguistic order to a non-spatial, non-linguistic one. which is based now on computable lines of written code in which humans are supposed not to interfere, at least in the last chapter, you know, the step 3, which is the blockchain. So of course this raised many problematic issues, especially in blockchain. 2 of them: absence of recourse to testimony, and testimony was very useful to allow complex situations to be synthesized and authenticated, and it's not the case anymore. And absence of means of coercion as well, because of course there is no police on the internet, so how do you make decisions respected once they are made? So policing is really a big task, very difficult. So why did I say that there is a splitting up of space? Well, in a way, space seems to have completely vanished. You know, we listened to talks online yesterday, for example, so we are here, but I mean, some participants are elsewhere in the world. But at the same time, space is still there, you know, and we know that there are cyber attacks trying to secure space. So space is still a crucial geostrategic stake. We have many examples of that, you know, attacks without declaration of war, of course, you know, on governmental and industrial sites, pipelines, nuclear sites, or services like parliaments, banks, or hospital. In this private sphere, you also know that there is this viral scapegoat mechanisms on social networks, which is obviously something that has to do with the fact that being anonymous, you can say what you want, and this has to do with the absence of space. So now, where does this situation of split come from? So I will do a little bit of history here, starting with 2 clues. First one, as I said, digital law is eligible for professional as well as citizens. And digital law is no longer written in full by legal professionals. So I think that the main problem is a semiotic problem, you know, and it has to do with how we read and write science. So let's go let's make a bit of history. My first remark comes from this beautiful book by Clarice Helmschmidt, a colleague of mine at the CNRS, who claimed already some years ago that digitalization is the latest step in the very long history of literacy. Okay, so I will talk a little bit about the history of writing, and I will allude to some clues in the history of mathematics. So 3 crucial steps in the history of writing. And the first one that I called Abjad, and I gave the Arabic letters here. I think it's a very important point to see that in the history of writing, the automatization has started long ago, much more than what we think. So Abjad is the way, it means alphabet in Arabic. It's one of the ways, the classical way of spelling the letters. It's not the case anymore, but it used to be that way. So Abjad appeared long ago, probably in Sinai, and it's an interpretation of Egyptian hieroglyphs. But what it makes, the big difference that it makes, it has no iconic resemblance with the objects that it refers to. So it's an exclusively phonetic interpretation of hieroglyphs. So there is an end of the connection to space in a way, because images are just put aside, right? So this is the first major step in I think the development of an automatic way of reading and writing. So in Arabic, as you can see here or there, so this is you write only consonants, you don't write vowels, and this has one very interesting consequence. It means that you can't actually read without knowing the language first. Okay, so I can't read this. Well, I did some Arabic long ago. But I have to know the language first. I have to know where to put the vowels to be able to decipher what is written. So one must know the language orally first in order to be able to read and write. The second step is alphabet, alphabeta. So this is, as you know, the Greek alphabet is inherited from the Phoenicians. And there's a major change in the alphabet, which has to do with automation, which is the fact that vowels and consonants are written down, both of them. So it's an exclusively phonetic scanning of vowels and consonants that doesn't need any semantic interpretation. And if you're like me, when you're tired at night and you're reading a page, you read the whole page, and at the end you say, well, but what did I do? I can't remember anything. Well, how is that possible? It's just because you have some kind of automatic scanning. This is possible. This is not possible in Arabic. In Arabic, you have to be active in your reading. Otherwise, you can't read just a single word. So this is something really new in a way. It means that letters can be scanned automatically without knowing the language in advance. So a machine can scan, not only us, but a machine, because all the semantic has been put aside and you just have to scan automatically. So the reading becomes automatic in the West. So the alphabet, to me, is the first automatic sign machine in Western writing systems. But there's a third step, which is the one that we are very much concerned with today, which is code. And my claim is that code is something really new because it makes the writing automatic, not only the reading, but also the writing. And of course, we feel completely dispossessed. There is something now that machines can do almost as much as we can. But in order to understand this, I have to go into the history of mathematics to show how in mathematics it's the situation of geometry that changed and that brought computability. So geometry is the norm of the mathematical space, as you know, and there's been a big crisis in geometry at the end of the 19th century, where mathematicians have discovered that Euclidean geometry was one among others. So which is the right one? Is it the Euclidean geometry, or is there another one? Riemann's geometry was used by relativity theory. So which is the right one? And Hilbert, the great mathematician, German mathematician, had a kind of trick. He said, well, we don't know which is the right geometry, so let's skip geometry. And let's try to make some kind of axiomatic of geometry that could be reduced to something really secure, which is arithmetic. And that's what he did at the very beginning of the 20th century. So the theory of space geometry lost its normative role as the source of theoretical intelligibility to the benefit of arithmetic. And this is precisely what happened with digitalization, But it brought many problems. So of course, when you read Hilbert, what you see that he's also fascinated by writing, reading and writing. So arithmetic is written with characters that can be listed in an alphabet. Okay, so it's an alphabetical take, and the meanings of these characters are completely put aside, so we can scan, just like when we read, there are only typographical marks. And the connection between these typographical marks can be monitored in a purely deterministic and mechanical way, which is a computation. So at that time, in the 20s of last century, mathematicians started to think, well, what is a computation exactly? We've been using computation since the beginning of mathematics, but what is it as a concept, as a mathematical object? And you know that one of the answers was the Turing machine invented by this British mathematician, Alan Turing, in 1936. So the way to answer Hilbert's question was, well, there is a way to describe computation through a kind of ideal machine, and this machine is what? It's a reading and writing machine. What is a Turing machine? It's only a reading, writing machine. Right. But there are at least three completely unexpected consequences of Turing's work that are slightly overlooked, I think. First, there are intrinsic and unescapable limitations to computability. There are problems that will never be solved algorithmically. Never. That's the first blow, in a way, to Hilbert's program. Second thing, computation can be implemented in real machines. That's, this laptop or our phones. So computers are finite-sized replicas of Turing machines that are infinite machines, okay? And third consequence is that computer programming makes computation automatic, okay? There's one little sentence or remark made by Turing in one of his articles in 1950 that I found very interesting. He said that mechanism and writing are, for me, almost synonymous. So he really pointed to the direction that I try to stress here, to say that, computation, mechanism in general, has to do with writing, writing and reading. So it's a semiotic machine. What is also interesting in this quote is the fact that he says it's almost synonymous. It's not completely synonymous, it's almost synonymous. Why is it only almost synonymous? Well, because there are limitations to computation, and the two things are not completely the same. So writing, through Turing's work, has become partially automatic through computation. So there's a new type of writing which is being implemented in the case of law, okay? In the case of digital law. So it's no wonder that digitalization of law has lost space as its most basic foundation, since what Hilbert did was to put geometry aside and focus on computation. So now, justice, in a way, needs space. So how do we do? How do we make things possible in the area of the rule of law? So I think there are at least three tentative solutions that we can think of. The first one is the collective participation to the making of algorithms. So this is typically a problem of digital literacy. To what degree can laymen and judges become literate? Since we are all illiterate today, which is very surprising, how did we become illiterate? The second thing is the agreement on what is delegated to software. So this is also, I think, a very important point. In a trial, for example, well, you have to make sure that everybody has an equal treatment. It means that the same software should be used by everybody. Okay? So this is something that has to be decided before starting the trial. What kind of software are we going to use? Okay? And of course, we also have to be very careful with the possible runaway effects, because as we know, algorithms can just strengthen biases. It's the case, in many examples. The one I've chosen is liberation on parole. In the US, there's a software that some of you may have heard of, which is called Compass, which is supposed to decide whether you can liberate someone on parole or not. So there's a list of 134 questions that you ask, and after a while, American judges showed that, in fact, black American would stay in jail and the white would go out. So how is that possible? How was the software made, in a way? What happened? So there was no bias in the software, So there was, of course, no line of code saying, well, African American would have to stay in jail longer than the white. But what happened was just that in the list of questions, there were, for example, zip codes. But of course, especially in the US, with a zip code, the race of people. That's very clear. So, just by asking very basic questions, you can introduce biases, and of course, these software can strengthen them. So we have to be careful. So, how to regain a sense of collective space in order for justice to be justice? I think we need hybridizing old and new forms of law. And we need also to find new ways of law enforcement in order to fight impunity through anonymity. And we need to have ethical rules that are made independent, from marketing strategies of big tech companies. So we have to reinforce the accountability of algorithms. And my suggestion, and I'm not the only one, of course, but I think at the European level, at least, we should have public commissioners to control algorithms, which both control them, know what's inside, and at the same time try to preserve business secrecy, of course. But for the moment, it's not the case. So when you have a software, the company would say, hey, I'm protected by copyright law. I won't tell you the code, But this is not possible because it brings, all the problems that I just mentioned. So this is it. The floor is yours.